What are the chances of you getting spousal support? You know what your marriage was like. And if you're filing for divorce and you all of a sudden end up not getting alimony or spousal support, you may find yourself in big trouble. You may ask yourself, how am I going to pay the bills? How am I going to continue living? These are big questions, and I have some answers. I'm Jim Kraayeveld, lead attorney at Kraayeveld Family Law. And after 30 plus years of helping people get divorced, I can give you a pretty good idea of what to expect. Let's dive in. Alimony, which is also known as spousal support, is a financial support payment made by one spouse to the other during or after a divorce. The goal is for the lower earning spouse to be able to maintain a standard of living that's reasonably comparable to that which was enjoyed during the marriage. Judges can also order alimony in gross, which is a form of property distribution, but that's not what I'm really discussing in this video. In Michigan, unlike some states, there's no strict guideline or formula to determine the amount of alimony. Instead, the courts evaluate each case individually. They consider a variety of factors to arrive at a fair and equitable decision. That's what they're supposed to do. So let's talk about those factors. When one spouse asks for spousal support, the judge has to review a set of factors. As of 2025, there are currently 14 factors that a judge has to review. So let's deal with them in the order that they're listed in most cases. That doesn't mean that the first factor we discuss is the most important, but a judge has to look at all of them. They might not all apply, but the judge will consider all of them. First, the judge is going to look at the parties' past relations and conduct. What does that mean? It's a bit of a fault issue. It's a bit of determining how people spent their money. Did they have an affair? Did they gamble? Did they go out a lot? All of those issues. The court will also look at the issues of fault. Did one spouse have a nasty temper or control the other spouse? Are all of those things that led to the breakup of the marriage? Of course, when a marriage ends, there's typically two people that are fighting, and a judge isn't going to fault the spouse just for asking their husband or wife to move out. Next, the judge is going to look at the length of your marriage, which is a fairly significant factor. Generally, longer marriages are more likely to result in an alimony award. For example, marriages that last 10 or more years have a higher chance of getting a spousal support award than if you have a very short-term marriage. Third, the judge is going to review the party's ability to work. So, the court's going to put a fair amount of emphasis on this issue. Does a spouse have the ability to support themselves after separation? And this factor is often heavily debated when one spouse has been a stay-at-home mom or a stay-at-home parent and hasn't been a member of the workforce for a significant amount of time. For example, mom had a nursing degree or didn't even finish her degree from college or was working towards a history degree, and that's been 20, 30 years ago. The ability to obtain gainful employment between the issue of a part-time college or not finishing college 20, 30 years ago and having a current nursing degree is pretty big. The fourth factor that the judge will review is the source and amount of property awarded to the spouses. It's sort of a tricky factor because even if you end up with a lot of assets, the court has to look at the income potential or income producing potential, not the overall value of assets. If you have real estate that doesn't generate income, it doesn't do much for you. If you get so-called liquid assets in the form of money and cash that can actually earn interest in the bank or at a brokerage, that's a different situation. The fifth factor to be reviewed is the parties' ages. When a spouse is 25, they can either just go right back to work or continue working or go back to college. And it's far more easier for them to get a job than someone who's 58, got a college degree 30 years ago, and hasn't worked in 30 some years. Next, the judge is going to look at a spouse's ability to pay spousal support. That's usually reviewed in conjunction with the need of the other spouse. So if there's a significant difference between the two spouses' incomes, the chances of spousal support increases. Similarly, the judge is going to look at the party's ability to work. Even if you want to retire in your 50s, the court might not allow that or may order you to pay support because you had the ability to go earn an income. Next, the judge is going to look at the party's current situation. Are there minor kids at home? Are there minor kids with special needs? Are there adult kids with special needs that prevent a spouse from working? Did one spouse take on significant marital debt? These are all things that the court will consider. The eighth factor is the party's needs. Obviously, this is a very compelling factor. Again, the judge is going to look at the party's situation. A mom who cares for the kids or a disabled child who's an adult has a greater need for support than a mom who could go and be full-time employed. Then the judge is also going to look at the party's health. If a party who's not working is suffering from a debilitating disability, the judge is going to take that into consideration. For example, in the case of Demon versus Demon, where the wife had cancer and needed ongoing treatment, the Court of Appeals held that the trial court had to take that into consideration. But in the case of Moser v. Moser, the wife had minor health problems. She didn't seek additional medical care. And even though she claimed she was short on money, but then she had money to go on vacation to Europe. These example cases outline that the courts look at each case on a case-by-case basis. The judge will also review the spouse's prior standard of living. For example, did either spouse support a third party? I've often heard one spouse, make the argument, well, she can make ends meet because, they were able to survive on a set amount of money. Survival isn't the standard, though, that the judge has to look at the amount of support. The judge is going to look at their prior standard of living. So I ask my clients, give me your previous budget. When you were living together, what did you spend your money on? If you're accustomed to a lifestyle that cost a couple $100,000 a year, the judge is going to take that into consideration. If a spouse produces a budget that the spouse is paying expenses for a significant other, then on the other hand, the judge is also going to look at, because you're spending money on someone else than the person you're supposed to be taking care of. Next, the judge will review each party's contributions to the marital estate. In other words, how much did each spouse contribute to the marriage? It isn't just a matter of, one person was the breadwinner and one person stayed home and raised the kids, because you're both contributing in that case. The judge is also going to look at who's at fault for the breakup of the marriage. And again, that's fairly self-explanatory. A judge may also consider whether a party is cohabiting. Obviously, if your former spouse moved in with a new significant other, the need for spousal support diminishes, and in some cases will be eliminated. Lastly, the judge will consider general principles of equity, which basically means the judge can look at what's fair. It's sort of a broad catch-all provision. Your next step in evaluating whether you will get alimony or spousal support is to review your situation compared to the factors that the judge has to review. What's your income? What does your spouse earn? How long were you married? What was your budget in the past? What was your lifestyle like? Again, there's 14 factors to consider. Maybe not all of them apply, but you need to look at all of them. Judge has a fair amount of latitude in determining spousal support. And after years of reviewing spousal support cases, a good attorney can give you a pretty good estimate of where you're likely going to end up. That said, you came here because you had big questions you're looking for answers. Let me give you some guidelines. Really, general rule of thumb is you got to be married about 10 years before a judge is going to start considering spousal support. Sometimes they'll go with less than that if there's a huge disparity or there are certain circumstances. I've had judges handle cases where judges did award spousal support after a 5-year marriage. But there's 14 factors that weigh heavily in favor of ordering spousal support in longer-term cases usually. Keep in mind, if you're married for 10 years or longer and your income doesn't vary that much, or there's a substantial child supporter that's going to come into play, even then a judge will probably order little to no spousal support. Permanent spousal support is very uncommon unless you get into really long-term marriages. So many support orders will provide for short-term support, allowing a spouse to go find a job or go back to college. For example, if you have a 10-year marriage, a judge may order a few years allowing for return to college to get a degree to get back into the workforce. But if a couple's married for 20, 30 years and the spouse is in their late 50s, it could start becoming a permanent support, at least until retirement kicks in. So, long story short, Determining spousal support is an art based on years of experience, calculating support, anticipating a judge's ruling, know how your judge leans. Experience does matter. If there's a potential for a spousal support order, consider the consequences. 10 years of $500 of monthly payments is going to cost you $60,000. It's enough of a reason to discuss it with an attorney on what to expect and how to proceed with litigation. Hopefully this was helpful. Until next time.